much for inviting me here. I am really grateful. Thank you so much, Honorable Vice Chancellor sir, for giving me this opportunity. See, we will not go into all the formalities. I like interaction-based classrooms. Basically, she has done very good my introduction, and I am basically a teacher of labor law, right? I have 12 years of teaching experience this particular subject. So sir has given me, or I have chosen these 3 topics to discuss. That is trade union and labor jurisprudence. And then secondly, we'll discuss dispute resolution mechanism. And last topic I will cover tomorrow, that will be the which semester? 5th semester. 7th? 5th. Okay. So you have understanding about labor laws, right?
Yes.
So I have divided this particular lecture in you may say 3-4 on the basis of 3-4 points. First, we'll try to understand what is the nature of this subject, right? Because labor law is so boring subject. Nobody takes interest in this particular subject, and we don't have very good faculty also to teach this particular subject, right? And it has a very good jurisprudence. This subject has developed very good jurisprudence through various Supreme Court and High Court decisions. But what is the nature of this subject? How this subject has evolved? That we have to understand first. So I would like to know, what do you understand by labor law? What do you mean by labor laws? Can anyone explain? Yes? What is your understanding about labor laws? And why it is called as a separate branch of law? Yes? Why it is called as a separate branch of law? Anyone? What is your understanding about labor laws?
Labor laws are those laws which are specially made for the benefit of the laborers.
Okay.
Protect their interests.
Protecting interests. Okay. Yeah. So here, see, it is basically a law for or group of laws, you may say, for the laborers, workers, you may say employees also sometimes, correct? And it regulates the relationship between the employee, or you may say worker, and the employer. And there is always tripartite relationship. So state intervention is also required, employee relationship is also required, and the employer relationship is also required. So these 3 stakeholders play a key role in dealing with the labor legislation. So I will just briefly discuss the evolution, and then we will directly jump to the trade union and labor jurisprudence. Okay. So here state role is very important. Why state role is important? Because we are living in welfare state. We had various types of states, you may say. Initially we had a kind of police state, we had laissez-faire state, we had you may say welfare state. And in the welfare state, we will see that labor has welfare schemes, social security schemes, and state has more obligation. Although the concept of welfare state has emerged after the Second World War, right? Initially we had a state like police state or kingdoms where the state has a very minimum role to play. They will just look after external affairs, they may look after collecting revenue and all, right? And protection from external aggressions. When you say a laissez-faire state, that is a French word that has evolved, where the state has very minimum role, or you may say no role to play in the activities of business. There may be more exploitation, that there are possibilities of exploitation of labor, and therefore we don't accept that particular concept. Only in the welfare state we have this mechanism. You may say that is a state intervention, or that may be any other schemes, social security measures also. And why it is called as a separate branch of law? It has emerged, like you have administrative law, you have a constitutional law, right? You have public law, private law, substantive law, procedural law. So what kind of nature of this particular labor law is? Whether it is a purely procedural law, whether it is a substantive law, whether it is a public law, whether it is a private law. What is the nature of this particular subject? Or is it a combination of both? Whether labor law is a combination of both? Answer is yes, it is a combination of both. It has, see, employee-employer relationship. When you say a private law, two parties are required, where employee and employer relationship is there. When you say public law, in that situation you need a state intervention or larger sections of the society. They will deal with those issues, right? Constitutional law is a public law. But here in labor law, it is combination of both. So you have this all understanding. Let us not go into that details, okay? And in the history, it has a very, you may say, very long history we have. Since you may say pre-independence period, from pre-independence, post-independence, we have enacted many legislations. We have borrowed all these legislations from UK mostly. Like we have this Employees Compensation Act 1923. And India was a party to ILO since beginning. We are the founding member of International Labour Organization. And we have many obligations. Although we have not ratified some of the important conventions out of 8 core conventions, right? You are aware about that. Out of 8 core conventions, India did not ratify 2 conventions. One is relating to collective bargaining and freedom of association, correct? And they don't believe in this freedom of association. Convention number 87 and convention number 97 of International Labour Organization, correct? So why they have not ratified, that is a different debate. But here today we are going to discuss only about the trade union. So how this law has evolved, you see the history, you see the colonial history, and then you see first National Commission on Labour. Before that we have a Royal Commission on Labour, that is also called as a Whiteley Commission 1930, which has given many suggestions. Thereafter we had a first National Commission on Labour of 1969, where Justice Gajendra Gadkar was the chairman of that particular committee. And they talk about clubbing of the legislation. Then when you see the reports of the second National Commission on Labour, right, which was constituted or established in 1999, and then they submitted report in June 2002. In that report, they talked about the clubbing of this legislation. You are aware that now we have 4 codes. Which codes we have? Code on Social Security, we have Industrial Relation Code 2020, we have Occupational Safety, Health and Working Conditions Code 2020, and we have Code on Wages 2019. And this idea was brought in 2002, when that time the then you may say Prime Minister Atal Bihari Vajpayee ji was there. So they have introduced this particular idea. And in 2020 we have introduced all these codes, 4 codes. But whether these codes are implemented? No, they are not enforced. And therefore we have to study both existing labour mechanism as well as you may say new provisions also. Correct? So now coming to these 4 codes, you can just go through this. First code we have, that is Industrial Relation Code 2020. This code was introduced in the Parliament initially in Lok Sabha, once it has lapsed, and then again it was reintroduced, and finally 28 September 2020 this particular bill has assent from the President of India, got the assent, and then finally we have notified, but not for the implementation. Correct? Now what is this trade union? So I am just going to compare Trade Union Act 1926, which has a very good history, and then Industrial Relation Code. So what is the history of the Trade Union Act? Do anyone know this? What is the history of the Trade Union Act? How the Trade Union Act has introduced? Yes, you have done Labour Law 1, Labour Law 2. You are in or 1 now? Yes. So in the history, you see we have various examples. In the city of Madras, Kolkata, then you may say Mumbai, Bombay, all these were the presidency towns, and there were many leaders also. If you see the history of Industrial Dispute Act as well, 1947, they had very good leaders like N.M. Joshi, N.M. Lokhande, okay, Mr. Dange, many leaders were there. And one leader from the Madras, that is B.P. Wadi. You might have heard this case also,
Yes.
right? This history you have done. So this case was of 1918 when the B.P. Wadia was arrested on the ground that they have done criminal conspiracy, because they used to apply Indian Penal Code. That time we had already Indian Penal Code 1860 under section 120B subsection 2 of IPC, right? So B.P. Wadia, why he was arrested? Because they want to increase their wages. They had their certain issues in many cities, right? After First World War, then you see after the Second World War. So this was the case of after First World War. After 1914 to 1918, if you see, in 1918, B.P. Wadia was arrested on the ground of criminal conspiracy because they don't have any immunities. The main reason to introduce the Trade Union Act was that they don't have any immunities or privileges. Under the Trade Union Act, section 18, 19, right? 17, 18 and 19, if you read. These all three sections talk about the immunities. What kind of immunities they have given? Civil immunities, criminal immunities, and immunities from tortious liability as well. And one, that agreements are not enforceable into the court of law, that is section 90. Similar provisions are there under the code also, that is industry relation code. So after their arrest, right, all the leaders from these cities, they realized why they have unnecessarily arrested these people. Along with him, 9 associates also arrested. And what was the charges? Charges were for breaching this criminal law, and they were propagating against the employer. It is called the Binny and Company, right? Buckingham, Karnataka Mills versus B.P. Wadia, very famous landmark case in the history of the trade union. After that, N.M. Joshi, he introduced the private bill, and that bill was, you may say, after his that initiative, the British government said that no, you don't do this. We will introduce our bill in legislative assembly, and you have to withdraw this particular private bill. So he has withdrawn that particular bill, and finally the government, that time the British government, they have introduced that bill, which is called the Trade Union Indian. Initially it was called as the Indian Trade Union Act, right? Later on, by some amendment, they have changed the title. Now it is called as the Trade Union Act 1926. It's very old. You see the legislation. So main idea here to give them protections from these particular unnecessary charges. Because if you don't give them any freedom, right? Freedom to strike, freedom to have their, you may say, protest, freedom to claim their increase in wages, although in reality it may not happen, that you may consider. Okay, in reality you will find lot of difficulties the labor working or working class has to face, right? But the purpose of the act to do the registration and issues relating thereto, or to deal with the issues relating to the trade union. That is what the main purpose of the Trade Union Act. Under this code, you see we have 104 sections, then 14 chapters. Chapter 3 deals with the trade union, you see, that is registration procedure, and this is from the code I am just giving you for your reference, right? And we have a definition clause also. Now, can anyone tell me why the definition of appropriate government is there under labor legislation? What is the purpose of giving this particular definition? What do you mean by appropriate government? Yes, what do you mean by appropriate government? Why this definition is there?
It may be state government or central government.
It may be a state government or central government, very good, but why it is so? Why it is so? Yes? Okay, very good. You are so clever student, very good. So your teacher is also teaching well here. So here appropriate government definition is there because labor is in the concurrent 7th schedule of the constitution. Right? Both state government and the central government have power to enact legislation. And how many we have a central legislation and state legislation here? In India, how many legislations we have? Central and state legislation?
More than 100.
More than 100 we have state legislations, right? And we have 40 plus, around 44, 45 central legislations. And Trade Union Act is one of the central legislation. Every state may have their own, you may say, the state legislations also, like Trade Union Act and all. So here, now we'll directly jump to this definition of trade union. This is very important, and thereafter we'll discuss some cases, very interesting cases under labor laws. High Court cases and Supreme Court cases we can give. Okay. Now what do you understand by trade union? What is trade union basically? Under section 2G, 2H of the Trade Union Act. Now we have section ZL under the code, Industrial Relation Code. What do you mean by trade union? What is your idea about the trade union? Yes, means a combination group of people, right?
Temporary or permanent.
Temporary or permanent, right? The group, it means a combination, right, of workers, combination of people. It may be for temporary or permanent purpose. Any trade union can be for the temporary or permanent purpose. Once that particular objective is achieved, you may close or withdraw the registration of the trade union, right? Or it may continue to have permanently. We can have trade union for a long time, and that registration is done under the Trade Union Act, correct? And thereafter, always it is for regulating these three relations. Which are those three relations? Workers and employers, employers and employers, and then workers and workers. And can anyone tell me why the word employee is not referred here? Why the term worker is here in the code also and in the act also, you see?
Labor laws are primarily made for protecting the workmen.
Workmen, very good. Now we don't have a definition of workmen under the code. We have only two definitions. That is a definition of worker and definition of an employee also. Both two different definitions are there. And there is a difference between these two definitions. What is that difference? How you will categorize that he may be the worker and he may be an employee? Based on the type of nature of work they were doing or they are doing. Basically, there are three terms you have to remember always. Whether they are doing supervisory work, whether they are doing managerial work, whether they are doing technical work, right, or administrative work. Most important is managerial and administrative work. Supervisory work can be done by the worker as well as the employee. Technical work can be done by both also, you may say, but managerial and administrative work only done by an employee. And in case of supervisory work, that particular person is doing supervisory work, the salary limit, that time in the old act, right, it was like 5,000 something. Now they have, you see, upper limit of this 25,000 something. It may change also, but there is a limit of the salary. If you are earning more than 25,000 rupees and you are doing supervisory work, you may come under the category of an employee. You may not be, then you may not be the worker. If you are doing the same work and you are getting less salary, then only you are the worker. That's why there is always this confusion. And why we have abolished the term workmen? We don't have the term workmen, although in the act, in the existing legislation, we will find the definition of workmen. Even the title of the employees, this Workmen's Compensation Act, has been changed, right? Initially that was called as a Workmen's Compensation Act. Now it is called as the Employees Compensation Act 1923 by an amendment. Okay, that is leave apart, that is different discussion. But here these three relationships are very important, and then they are having, or you may say, for imposing restrictive conditions on the conduct of trade or business. This relationship is to impose restrictive conditions on the trade or business. Why? Because this immunity we have given to them. Otherwise, what will happen? You have the Indian Contract Act, right? Can you impose some conditions? Restraint of trade is void agreement. You cannot have restraint of trade agreement relating to restraint of trade. But here you may have an agreement to restrain the trade. That is what the definition says. Otherwise, section 27 of the Indian Contract Act will apply. And that may say that no, can you have the agreement to restrain anyone from marrying with any other, right, each other? We can't have such agreements. Nobody will stop you unless that majority act or whatever the age has been prescribed by the government for marriage. You cannot have any such agreement where you are restraining marrying with each other. That is not permissible. You have all this freedom. If you are 18 and 21, whatever the age is there, you are free to marry. Nobody can stop you. Even your parent can't stop you, and you can't have such agreement, right? So you have all this freedom. Now coming to this definition, they may impose restrictive conditions, and also includes federation of 2 or more trade unions, right? Here you may have this particular freedom, right, to have federation of 2 or more trade unions. Federation means combination of 2 or more, they can come merge together, or one name they may carry, or it is up to them based on their understanding, agreement and all, mutual understanding, they can do so. Thereafter, this particular definition has given 3 provisions to this definition. Have you analyzed these particular 3 provisions? Have you attempted to analyze these 3 provisions? Why they have given these 3 provisions to this definition? First one is any agreement between partners as to their own business, or any agreement between an employer and those employed by him as to the such employment, and last one is any agreement in consideration of sale of goodwill. You can have this freedom, but except these 3. If suppose someone wants to sell his particular company, business, right? If he wants to sell his goodwill, he is free to do. If their partners wants to have any agreement, then they are immune from this particular imposing restrictive condition. Otherwise, every time trade union will come and they will say that no, you can't do this. And secondly, this is more problematic. You may say this is contradictory with the definition. Any agreement between an employer and those employed by him. So you are giving here freedom. So there is one judgment, you can read that, T.K. Rangarajan judgment, right, versus I think state of Tamil Nadu, T.K. Rangarajan, 2003 judgment. In that judgment, Supreme Court has analyzed this particular aspect. They said that this is only with regard to the employee and employer relationship, right? We have to keep this relationship alive, that is more required. And that freedom has to be given to the employer. Otherwise, every time trade union will come and they will try to disturb the activities of the trade union. Thereafter, we have a definition of trade union dispute, industrial dispute, that we can discuss later. Now, we will discuss some of the landmark cases. You are aware about this Tirumala Tirupati Devasthana case, right? This is Supreme Court judgment, very interesting case. And then we have one more case you can note down, that is Rangaswamy versus Deputy Registrar of the Trade Union. Thereafter, we have a case of Tamil Nadu non-gazetted officers, right, versus that is also Deputy Registrar of the Trade Union. Now, what is this case about? In Tirumala Tirupati Devasthanam case, they have a department like Power and Water Works department, right? It is very famous place, devotees place, and they had 1,000 of workers working. Different departments are there. Many departments they have. Maybe electricity department, maybe power department, water department, and these workers, they have decided that we will form one association, one trade union, and those workers were working in Power and Water Works department. So they apply to the registrar of the trade union. If you read section 4, 3, 4, 5, 6, 7, 8, 9, 10, all these sections are very important sections. 3 onwards, right? Appointment of registrar is there, then other procedure is there, application, mode of application, then certificate of registration, all these provisions are there. So they apply to that particular district, and then registrar has given the certificate of registration. Here who went to the Supreme Court? Tirumala Tirupati Devasthanam went to the Supreme Court against that particular trade union, which has been already registered. Matter was before the High Court also, and then finally has reached to the Supreme Court. Correct? Why they went to they said that this certificate has to be cancelled. They are not the workmen, right? Whether that Tirumala Tirupati Devasthanam is an industry. While discussing definition of industry, definitely we'll look after that aspect. But whether it is an industry, is there any relationship between this employer and employer, workmen? Because that time or even today, if you see the Trade Union Act, there is no such definition of workmen under the Act. We have to borrow the definition from the Industrial Dispute Act. That is section 2S of the Industrial Dispute Act, 1947. So they were interpreting this particular definition, and whether it is a paramateria, right? We have to discuss both these acts, because one act is different, this act is different. We are reading together both these legislations. So whether we should consider them workmen, and whether the certificate has to be given. So here, right, finally the Supreme Court, after going through all this discussion, deliberation and all, they said that yes, they can have the trade union. Why they can have the trade union? Because there is an employer and employer relationship. In that particular Power and Water Works department, they have this relationship. They are getting salary, right? They are bound by certain regulations also. And if you see the definition of industry, that particular department may be an industry. Except if you read Bangalore water supply case that we can discuss, where 3 tests is given, 3 things has to be fulfilled. Correct? So this particular department has fulfilled this particular test, and already that time Bangalore water supply case was there. In 1978 already that has been decided, and this case was of 1995. So here they said yes, they will have the certificate of registration. They should continue with the certificate of registration. Thereafter, if you note down the name of this case of Rangaswamy Stalin, right? Not Stalin, Rangaswamy only. Rangaswamy versus Deputy Registrar of the Trade Union. That is from Madras High Court. Now I will give you the facts. You tell me whether the certificate can be given or not. I will give you 2-3 facts as you are aware about that case as well. Okay. This you are aware. This is similar from Madras High Court, another case. In Rangaswamy's case, in Madras, they have a Raj Bhavan, right? two Rajbhavans are there. One is at some places, I don't remember the name, Octomund something and Gunti somewhere. Two Rajbhavans are there. And they have a total 102 workers. Some 35 workers were working in one Rajbhavan, and in another Rajbhavan, some 50 plus workers were. Total 102 workers were. And all these workers were doing this domestic kind of work. Some may be tailors, right? Gardeners. Some may be you may say domestic household workers. And all were appointed by their Madras, you see, governors, regulation. They have their own like regulation. And they were appointed during that particular pleasure of the governor, that all power were vested with the governor. And apart from that, all these workers, what they were doing, they were growing vegetables. Plantation, they have very good vegetables surplus also. So whenever they have a vegetable surplus, they used to sell that surplus vegetable in the market. And they have their own vehicle also. They used to have one vehicle. Very old judgment, right? And one day they all came together and they have decided that we will form one trade union. They applied to the registrar of the trade union. Okay. Then the registrar of the trade union, under section 3, right, it may be appointed by appropriate government. Now as per the code, it may be appointed by the state government. Okay. For one area there could be one registrar, two areas also one registrar, maybe more than two registrars, right? One for one area, that is also possible. By notification, they can appoint anyone. So registrar has refused to give the certificate of registration. Then they approached directly to the High Court. And do you know, under section 11 of the Trade Union Act, there is a provision where you can directly approach to the High Court. There is an appeal apart from the writ jurisdiction. Under Article 226 you can go always. That remedy is available. Under either you will go under writ of mandamus, right? Mostly the mandamus. But here under the Trade Union Act, that is one of the beauty of this act, that under section 11 you can directly appeal against the grievances, against refusal, right, against any issues. If registrar has refused to do the registration, or if that particular registration has been cancelled. There are many cases you can see where went to the High Court under section 11. Now they were arguing before the High Court that they are this group of workers and they should get the certificate of registration. Now what do you think? Whether they will get the certificate of registration? No? Why?
Because the exercise is sovereign legal function. The order is a sovereign legal.
Okay. Yes. Anyone else? Yes. So they did not get the certificate of registration.
They are exemption for
because they were working under that governor rules, regulations. They were doing the domestic nature of work. So they did not consider their argument and they said that no, you can't do the registration. Okay. Now coming to this another case here, Tamil Nadu Non-Gazetted Government Officers Union versus the Registrar of the Trade Union. Now what was the issue here in this case? Issue was very simple, whether they were workmen. Because here some of the people, you see, they were mostly non-gazetted officers, except defense services, right? They are excluded, they are not part of this. And whether the gazetted officer or non-gazetted officers can form the trade union, that was the question before the High Court. And then they interpreted the definition of workmen. They said that whether these particular officers are the workmen. So in this case also the High Court said that no, you cannot form the trade union because here category is different. They have refused. And then we have other cases that we will discuss rapidly, and then we will discuss cases relating to cancellation of the trade unions. Okay. Now if you read this BSP Hanumanta Rao case versus Deputy Registrar of the Trade Union. This is from also Andhra Pradesh. Right. Here in BSP Hanumanta Rao case, before we go to these cases, let us just have a look of this. Look at these particular sections. Section 9, 10. What is section 8 and 9 of the Trade Union Act? That is for registration of trade union. And which section provides cancellation of trade union? Section 10. And when the cancellation can be done? What are the grounds to do the cancellation of?
Voluntary application.
Obtained through fraud.
Okay.
Not only the provisions of.
Okay. So you have done this all sections? Some of them. Okay. Now see, section 7, 8 of the Trade Union Act, right? 8 and 9 also, where certificate of registration is given. There are certain criteria. Who can apply? 7 or more persons can apply. Apart from that, what is another condition? Minimum 100 or 10%, whichever is less, that number is required. And suppose that number went less than 7, then registration
Cannot tax.
but whether the registration process can be proceed further if number is less. Have you gone through the provisions? See, in the Trade Union Act, you have to read section 8, and also there is one section, that is section 9 capital A, right? And similarly, you have to also read section 22, proportionate number of office bearers as well. How many can be there? So under section 8, right? Initially, while applying for the registration of the trade union, minimum 7 are required. And when the application is pending before the registrar, even if that number has went down, he may proceed with the application, but that number should not be less than 5. So minimum 5, half of the number is required to continue with the application of registration. But despite of that particular fact, right, if you see this section 9, right, 1, 2, 3, 4 subsections are there. This is just similar to the act only, I am referring to the code. So under 1, the registrar has to be satisfied, then you can read 1, 2, 3, 4, and then they should have a 10% or 100 workers, and all the time they should continue to maintain that particular number. If you don't maintain that particular number, then your certificate may be cancelled. That is essential criteria. So initially while applying, you may have 7, and then you have to give the list. 7 may be the office bearers also, like president, vice president, secretary, treasurer and all. And then 10% or 100, whichever is less. Okay, but that number may go less than this 10 also, 7 also. Now coming to this section 9, which is similar to section 10, cancellation of trade union or withdrawal. So when the trade union can be, certificate can be cancelled or withdrawn? But by not complying with the act, right, if they are contravening the provisions of the act, like they are going less than that particular number. Secondly, they have obtained the certificate by fraud, mistake and misrepresentation. Okay, and then you may also say that there should be 2 months notice.
Yes.
Now it is 60 days notice. If you did not serve that 2 months notice, okay, to that particular trade union, you cannot cancel the certificate. So there are 2-3 cases I will give you for the this particular cancellation. Okay. Now in this, here little different view they have taken. That is Bokajan Cement Corporation versus Cement Corporation case. This is relating to automatic cessation. That is different issue. Okay, these cases are not there, but I will just tell you the names. You can note down. There is a case of ECIL Employees Union case versus Deputy Registrar of the Trade Union. And there is one more case, that is Coromandel Cement Factories case This is also versus Deputy Registrar of the Trade Union. In both these cases, they discuss section 10, where they have discussed that when cancellation can be done. Now coming to the facts of these two cases, right? Registrar has cancelled the certificate in one case. Why he cancelled? And he was saying that they have served the notice, they contravened the provisions, but whether actually that particular notice has been served, whether 2 months notice has been given to the trade union. If you have not given that 2 months notice, then you cannot cancel the certificate. Okay, so these two cases you can note down: Coromandel Cement Factory and then ECIL Employees Union case. Both are relating to section 10. Now coming to very important issue I will discuss. For that I have to discuss this in detail, and I may ask you questions also. Whether the retired employee can form the trade union. Whether retired employee can form the trade union.
Yes.
So why? How? If you read the provisions,
Such as gratuity and the pension regarding that if any leaves are to be dealt with the employee.
but see, the Act says, definition also says, under section 6 also they have given, 22 also if you read, right? It says that that person should be actually employed and engaged in the employment. Then only they may be covered under the Trade Union Act.
So, but they also mention a term any person.
Okay.
So that under that ambit, this retired employee will also be covered.
Okay. So you have gone through this Demagogy Tea Estate case. You said any person, then you must know this case. Without this case, you can't know the any person. Okay. So this is very landmark decision, right? This is the case of workmen of Demagogy Tea Estate versus management of Demagogy Tea Estate. Supreme Court judgment, 1958. Very old judgment. And here Justice Sudhiranjan Das, right? He wrote this particular judgment, and they have discussed this particular issue of any person. Now, what do you mean by this any person? Whether that any person means any XYZ person on the road can be the any person? Can you say that? And they also refer the term here. If you read this definition, now since you raised this issue, I have to discuss this definition also. Like industrial dispute. What do you mean by an industrial dispute?
Any dispute that is between the workman,
Okay.
employer and workman with relation to the terms of the employment
Yes.
and non-employment issues.
Conditions of the
Conditions of
labor.
the conditions of the
Okay. So what is non-employment here then? When you say it is a non-employment?
Retrenchment.
Okay. Yes, good. So why we have referred non-employment here? Because here there may be a termination of services. That may be retrenched also. Employee may have been retrenched. So in that situation, employer should not say that I don't know this person. He is not in my employment. He is not on roll. He is not registered. So why should I consider? So any dispute or difference between these three groups, again three groups, may be an industrial dispute, and that should be connected with the employment, non-employment, terms of employment, conditions of labor, working conditions. And then whether an individual dispute is an industrial dispute.
Sufficient number of people to suffer.
Okay, very good. You raised very good issue. I like this point. But does this is required all the time?
Only when there is consent of the majority.
Okay. So does that principle still continue to hold?
Majority is not required.
Majority will be not required.
Substantial amount.
Suppose he has some issues and nobody is ready to support him. He is just alone, one individual, and he has issue with the employer. Whether that dispute is an industrial dispute,
It's an individual dispute.
it's an individual dispute. But still that jurisprudence is same, or they have changed it. You have very good understanding, no doubt. You raise very good point also. But whether it is always necessary to have this group of majority, I may have my own issues. Substantial is also not required. Why substantial you require? Who will come to help him? Not necessary. Therefore, you see in the new code, they have added this particular line after that any person then includes any dispute or difference between an individual worker and an employer connected with or arising out of discharge, dismissal, retrenchment or termination of such work. This was the old jurisprudence, whatever you are talking, labor jurisprudence. Why? Because when this law was enacted, there is Supreme Court judgment also, they have discussed this particular issue. There is one case, I don't remember the name, but somewhere that case or many cases where they have this particular understanding. Here it is not that case, but if you see this particular definition, right, in many cases, whatever you just said, that has been observed. Even the High Court, even the Supreme Court, they were always saying, we need a substantial number of workers. Without that, how you can say? Because initially, when the law was enacted, they were not talking about the individual. They were talking about the group of persons, trade unions. And even if you see the definition of trade union or trade union disputes, it is between the trade union, right? Between the employer and trade unions. Generally, they were considering and member of the trade union and trade union. That is called the trade union dispute. So initially, many judgments till maybe 1960 or 65, in which even the Supreme Court, High Court, they said you need to have some support. Okay, that issue has to be espoused by the group of workmen, and then similarly, then we can discuss this workmen of Dimakuchi Estate. Now I will tell you the facts of this case. Now in this case, there was one doctor, Mr. Banerjee, somewhere it may be mentioned, PK Banerjee or I don't know, but some Banerjee, doctor was there. And he was appointed as assistant medical officer in this workmen of Dimakuchi Estate, and he was appointed on contract something. His duties was to just look after the workers, their health issues and all. Right? And in the contract it was already written that in lieu of 1 month notice, can you open the PDF file of this case? Workmen of Dimakuchi Estate. Just open that PDF file. And that doctor was terminated. His services were terminated. On what ground services were terminated? The ground was that he, in one of the incident, right, since he was medical, this doctor, he did not treat well the patient, their patients, and they have complained it to the employer, and they found him some incompetent, something like that. And then they said that he will serve you the notice, either you serve the notice or in lieu of notice we will pay you the 1 month salary in case of contractual employee, and then your services will be terminated. This doctor was terminated, services were terminated. Just little zoom it. Okay. So, yeah, it's visible. Take it. That's fine. Yeah, KP Banerjee, right? So, services were terminated, everything is done. Then this doctor was not that much interested in the service, but they had one trade union that is called Assam Karmachari Sanghatan something. They came forward and they have raised this issue because espousal is required. Thereafter they had many questions whether 2 members are sufficient, 5 members are sufficient, 10 workers are sufficient, or all the trade union will come to protect that particular individual. So his services are gone. But the trade union were arguing that will ask the employer to reinstate your services, because reinstatement is only that solution that his services may be reinstated. Okay, how much time we have?
1 hour, sir. 1 more hour.
One more now. So we will take continue or will continue? Okay, no problem. So we can discuss that another issue also. Now here they may get bored also, because labor law is already boring subject, I know. We have done this. Chicken. So here services were terminated, and ultimately this matter has reached to the Supreme Court. Okay, so Dheeraj Das was the judge. And main issue was that whether that doctor is a workman, right? Whether he is a workman, and whether his services can be reinstated. Whether his services can be reinstated in that particular employment, and whether the support of espousal of the trade union is also required. Because as you said, you have very good understanding. You said कि support होना चाहिए, right? Espousal होना चाहिए. But भाई हमेशा कहाँ से support लाओगे? Nobody will come to support you. एक इंडिविजुअल के लिए क्यों कोई सपोर्ट में आएगा? इसीलिए therefore you see in the Industrial Dispute Act they had an amendment in 1965, and they added the term, right, this particular sentence under section 2 capital A. It says individual dispute is deemed to be an industrial dispute in case of retrenchment, termination, dismissal, discharge of services. So even if one individual services are terminated, that may be an industrial dispute. So they have to change this, because it is not possible all the time that all will come together and they will raise the dispute. Now while discussing this particular case, the Supreme Court has to go through that particular term, any person. You can zoom or you can go down. They have explained this particular term, any person. So who is this any person? Whether this any person means any person on the road? No. Right? Either this person should be connected. He may be previously employed. Right? He has something to do. He may be the contractor. He may be the subcontractor. Right? He may be the third person also, but who has some role to play. If he has some role to play, in that case, you may include that under that particular definition, any person, right? And therefore, this workman of Dimakuchi case has interpreted the term any person in one of the paragraph. If you see one paragraph is there, I will just go down. Again, there is one paragraph where I have highlighted any person has been interpreted. Okay. Although this judgment has not given anything in favor of the doctor, right? Judgment was not positive about the doctor, because they were not ready to reinstate their services. He was terminated on the ground of that medical unfitness, or you may say he was not competent to deal with the patients, and he was contractual employee, right? Okay, take it. Leave it. You can leave it. So here Supreme Court was not ready. But why this judgment is important? Here, any person. That interpretation is there. So you have to read this particular definition for any person. Now we will go back to the PPT, where we have to discuss this particular issues, whether the retired employees can form them, because that was our main issue. Since you raised this any person, I have to discuss this case. Okay. Now Whether retired employee can form the association, whether retired employee can be the member of the trade union, and whether the retired employee can be the office bearer.
They can form an association and they can be a officer.
Yes, concept wala hoga. Go down, concept of labor law. Yes, so there is a judgment of yes, good. Yeah, leave it. There is a judgment of Karur Vaisya Bank Retired Employees Association. Very famous case is there. Okay, this case versus Deputy Commissioner of Labour. This is a High Court case, but I will give you Supreme Court cases. Don't worry. Right. So, in this High Court case, there were many. Thank you. There were many retired persons. This is all group of retired persons. And all these group of retired persons, they thought that we will have one trade union. हम एक trade union बनाते हैं, and that trade union will work for the issues relating. Registrar was not ready to give the certificate of registration, and he rejected the application. On what ground he rejected the application? He rejected the application on the ground that he, as per the Act, as per section 6E, section 22 clause 2, right, 2, 3 you can read 22, section 22. The person who are actually employed and engaged, only those can form the trade union, and not the retired employees. And you are the retired employee, so I will not give you the certificate of registration. That was the decision, and then they challenged this particular this issue before the High Court. Now, High Court has to look after or discuss the issues that whether this group of people, right, whether they are the workmen, like you said, any person, right, now they are retired. And if you read the first sentence of the judgment, second paragraph, first line of PDF file, where it is mentioned that it is not in dispute that they were previously employed. They were previously employed, so there was no question whether they were employed or not employed. Just second paragraph, first line, you read that. But the dispute was that whether we should give the certificate to the persons who are retired from the services, and whether they can be the office bearers. This is another issue, but here that was not the issue. Here only whether they can get the certificate of this registration. So here, after going through all these interpretation sections and all, and even if you read one case, now I will give you another case also. In Government Tool Room and Training Center case versus Assistant Labour Commissioner, that is from Karnataka High Court. In that case also there were group of employees. You just keep in mind that they were working in various departments of the government of Karnataka, and they applied for the registration of the trade union, right? And they have a supervisory officers, means those who are or who were doing the supervisory and managerial type of work in that particular case. There also the registrar has refused to give the certificate of registration in Government Tool Room Training Center case, stating that you are doing supervisory and managerial work, so you will not come under the definition of workmen. Then again High Court has to say whether it is paramateria, whether we have to discuss all these two legislations together, and whether the certificate can be given to the trade union. That was basically the issue. Then in that case, apart from Rangaswamy case, apart from the Tamil Nadu non-gazette officers case, and there is one more case also, 2-3 cases. Here in this case, the High Court said that here it doesn't matter who constitute the union, but what is the purpose and object of the trade union, that is more important. So here High Court said there is nothing wrong in granting a certificate to this category of the officers, right, government officers, if their object and purpose is to deal with the trade union issues. So here, who constitute the union, it is not important. What is the purpose and object is more important. And similarly, now you come back to the Karur Vysya Bank retired employees case. Here they said ki whether we should give certificate to them. These are all retired employees, right? We should not give certificate. Okay, but finally here the High Court, this is High Court case, they said that ki even the retired employees can form the association. They have only one issue. Even the retired employee, irrespective of the term, the definition which says that you should be actually employed and engaged in the employment, because they are not now actually engaged or employed. But one more point High Court highlighted here, they said ki you cannot raise the dispute relating to the existing employees. Okay, you can form the trade union, but you cannot raise the dispute relating to existing employees. So here they said retired employees can form the association. Now there is one more judgment, just I will tell you, okay? You can read that PDF file also. There is a very famous case under labor law, that is State Bank of Staff Association versus State Bank of India. AIR 1996. This is the judgment of 1990, Supreme Court judgment. Now in that particular case, SBI Association case, where Harish Salve also argued, that time he was the advocate for the SBI. Even today he is the advocate of SBI, right? Where he lost that particular case very badly. You know that video also, how the Supreme Court has reacted to his argument. In the case of that voters, this disclosure of list, SBI has to disclose the list. Do you know that video? Where he was arguing for the SBI, right? Then court said very badly, and they did not give any relief to SBI in that case. They said disclose the list, and thereafter they have to disclose that particular means collection of the political parties, right? That is only case where he lost recently in 2023. Okay? Yeah, in that case. But he was the advocate in 1996 also. From 1996 he is arguing for SBI. Okay? In SBI Association, Staff Association case. And then there was one more advocate who also discussed, or he was an intervention by intervention he was the party. That is advocate Rajiv Dhawan. Rajiv Dhawan also argued, Harish Salve also argued, both were there. And then the issue, now I will tell you the facts, what happened in that case. Similar, it is connected with this case only. It may not be here, but it is connected with this. In SBI Staff Association case, this matter was from the Lucknow circle. SBI has, in that case, they said they have 19 head offices, they have branches, they have circles, okay? And each branch employee is the part of that particular SBI Staff Association. And they have one more wing which is working at central level, that is called as a State Bank of India Federation. Okay, so one federation is there. Federation, you may say central level, and in the regional level circles, branches were there. And in that case, in 1994, Mr. Avasthi, he was appointed as a General Secretary in 1994 for the period of 3 years in 1994. And thereafter, after only 1 year after, in 1995, he was retired. He is supposed to carry position for 3 years, but he was retired after only 1 year due to the age of automatic retirement or superannuation. since he retired from the bank, SBI has issued one circular, one order you may say, that has been impugned order as per the judgment. And in that order, SBI General Manager, whosoever is there from Lucknow Circle, he sent a letter to the central office also, and to the federation. They also agreed. Now you are retired from the bank, you are appointed as a general secretary, you cannot negotiate with the bank. Why you cannot negotiate with the bank? Because bank is such a financial institution. They have clauses of secrecy, fidelity. It is a credit institution, and we cannot negotiate with you. It is only the serving employee who can be the president or who can be the general secretary. Those people can negotiate with the bank, not the retired employee. Then this matter has been challenged. Similarly, many writ petitions were before the Allahabad High Court. Many writ petitions. One of the petition was for relating to this election also. Whether the election was valid or invalid. Now here question was whether he can continue to hold that particular position as a general secretary. And they also observed in second, third paragraph, they gave one incident from the Bombay Circle. Some Mr. Charles, that time Mr. Avasti was the president previously, and as a practice of the bank, they said ki we don't allow any retired employee to dialogue with the bank because we have many secrecy institutions. We don't continue to have such dialogue. Right? So in that case, when he was the president and Mr. Charles was the general secretary, this Avasti agreed on that particular point. And in 1996 also, this federation, they sent letter to the central office. Federation also agreed ki theek hai, we agree with you, you cannot continue to have dialogue or negotiation. Now ultimately matter was before the Supreme Court. And they were interpreting the term that he should be actually engaged or employed. Okay, he is not employed, he is retired. Okay. Then in the last paragraph, when Harish Salve argued, in his argument he brought another aspect. He challenged the validity of the election of the trade union. He said that as per clause 38, they have their own clauses, constitution. SBI Staff Association, they have their own clause. So they referred clause 38 and clause 42 of the Staff Association, and then they said that as per these two clauses, the election which was held in 1994 in their certain general council meeting, triennial some meeting, and it was for 3 years, that election itself is illegal election. And while he was arguing, as per 38 and 42 clause, in that clause it is mentioned that, if I could handle PPT I could have shown you, but forget about that. But here 32 and 38 and 42, it is mentioned that once the tenure of that particular post is done, you need to conduct the election within 9 months or maybe 6 months. And if you are doing that after that particular duration, if you are appointing or electing anybody for the general secretary, it should be ratified by the registrar of the trade union. But by default, or you may say by fact, they did not ratify the appointment or election of that particular Mr. Avasti as a general secretary of the trade union, and therefore Harish Salve argued that this is illegal election. So there is no question to proceed with this case, and there is no point in discuss in this particular case on the basis of merit, because your election is itself invalid. So there is not much good outcome of this judgment, but the point here is to mention, the Supreme Court also observed that the retired employees can be the part of the association. Retired employees can be the office bearers of the trade union. Okay? But they cannot negotiate or dialogue issues relating to the existing employees. You cannot raise. You can raise your own issues, but not the issues of the existing employees. You may be in the body, you may be the office bearer, because 5 is required, minimum 5. Rest can be the outsiders also. So there are categories of the members. Some may be ordinary members, some may be honorary members. That another case I will tell you. Okay. So in that particular Supreme Court judgment of 1996, court said he may, means in that case Avasthi did not got any relief. Okay. But observation of the court was that you can continue to be the member. You can be the office bearer, but you cannot represent the issues of the trade union, of the existing employees. Whereas existing employees may raise the issues of the retired employees. But retired employees cannot raise the issues of the existing employees. This is also one of the observations. Then thereafter there is one more interesting case that also you can note down. That I found it after some discussion. That is S. Velyapati. There is one case. S. Velyapati. I think this is from High Court. Okay, the High Court judgment. S. Velyapati, which has been again upheld by the Supreme Court also. Now in S. Velyapati case, this is 2019 judgment. In S. Velyapati, similar issue has been raised. Whether the retired employees can be the office bearer, whether the retired employees can be the member of the trade union, right? So in that High Court decision, again the same thing they have stated that yes, you can be the member, you can be the office bearer, but you cannot represent the issues. And the same High Court decision was upheld by the Supreme Court also. Because it has why I am telling the Supreme Court? Because there is no detailed judgment by the Supreme Court. The Supreme Court has given one paragraph. High Court has a detailed judgment. Okay. So you read that particular case. Okay. This is what regarding you may say the trade union. Now you just understand up to this. Now we will go back to our another issue. Okay. Because I have to cover two topics: dispute resolution, right? Settlement of dispute, and definition of industry as well. So under this Trade Union Act, you have to read Karur Vysya Bank retired employees case, you have to read SBI Staff Association case, you have to read S. Velyapati case. These three cases are very, very important, right? Then what do we mean by this industry, and what are the dispute resolution mechanisms under the Industrial Dispute Act? Now you are aware about the definition of definition of industrial dispute. Okay, means any dispute and all. You are aware about the workman, okay, any person also. And what are the mechanisms given under the Industrial Dispute Act? What kind of mechanisms we have? So for that you have to read the Industrial Dispute Act, 1947. Now under the Industrial Dispute Act, we can discuss without PPT. Is it fine? Okay? Okay. Because I am just talking, you people are just listening without this, that may not help you, right? So Industrial Dispute Act came in 1947. The purpose of the act was to have the intervention of the state. Okay, intervention of the state. Why intervention of state is required? Because during Second World War, okay, 1942 onward, 43, 44, 45, there were many strikes and lockouts. We had some Trade Dispute Act 1929, ऐसा नहीं कि we don't have any legislation, but legislation came in 1947, main legislation. Okay, we had the Trade Dispute Act 1929. Under that act, there were not proper mechanism to deal with the disputes. So it was very difficult during war situations and after the war to handle the working class. So in 1944, the government of India had issued one ordinance, and that is called as a Defence of India Regulation, DIR, Defence of India Regulation. And ordinance is valid for only 6 months. Why they have to do it? They have to do it because there were stoppage of work, workers were protesting, shutting down the place of employment, no production. If there is no production, no profit, right, no outcome, and no state intervention also. So through DIR, the state has started intervening in the affairs of the trade union, in the affairs of the industrial disputes. And it was about to expire because ordinance has to expire. And they found that this particular intervention, through that intervention, they were resolving the disputes very easily they have handled the situations. Because any dispute has to be decided or adjudicated by that particular forum, compulsory. So they avoided that situation. Now they thought, why should not we continue this particular mechanism? And therefore, in 1947, this particular Industrial Dispute Act 1947 was introduced. That was main purpose. And even if today, if you see Section 10 of the Industrial Dispute Act, which is similar to the Defence of India rules, just same paragraph, same section. Whatever they have discussed in 44 and 45, the same provision has been continued under the Industrial Dispute Act under Section 10 and 10A, that is voluntary reference to arbitration. Section 10 is reference to Labour Code, Board, or reference to courts. Right, that was the main, you see the history behind the Industrial Dispute Act. Now, Industrial Dispute Act defines this definition of industry. This is very important definition. Now, under definition of industry, Supreme Court and High Court also confused. They did not give clarity, and they have to discuss and deliberate for 10-20 years to finally decide what will be the industry, whether the university can be industry, whether the hospitals can be the industry, right? They have to discuss all this. Can you say this university is an industry? No. You will say easily no, right? Whether the hospitals are industry. So there are many cases. Now I will give you this name of the case, you can note down. That is State of Bombay versus Hospital Mazdoor Sabha. Or before that also, in 1953, we had a case of Mr. B.R. Banerjee versus P.R. Mukherjee. This is Supreme Court judgment. B.R. Banerjee versus P.R. Mukherjee, 1953, Supreme Court judgment. In that case, Supreme Court has dealt with this particular aspect. What can be the industry, what cannot be the industry. Right? I think I should show you the PPT, otherwise you will get confused. Just hold on 2 minutes. You should also take 2 minutes break. Now in the state of Bombay versus Hospital Mazdoor Sabha, okay, and that PR Banerjee versus Banerjee versus Mukherjee case, Supreme Court has to elaborate what should be the industry, when we can say that this is an industry. Okay. Here main issue was whether hospitals are industry. This is Supreme Court case. And in this case, Supreme Court said that these hospitals are not industry. Section 2J. You can read the definition 2J. Industry means any business, trade, undertaking, manufacture, calling of employers, and includes any calling, service, employment, handicraft, right? And they said that it will exist only they have relationship and all. Most importantly, they should involve in any trade or business. And this is from Bombay. So here there was one employee who was working in JJ Hospital. Initially, JJ Hospital was a private hospital. I think Tata, Jamshedji Tata, who established that particular hospital. And thereafter, government has taken over that particular hospital, JJ Hospital. Okay. So he was terminated from the services, and then for retrenchment compensation, he should get the compensation. He approached the court under section 25F, FF, right? Main issue was he should get the compensation. So he went to the court, he went to the High Court. Then the question before High Court was that whether this hospital is industry and whether we should give retrenchment compensation to this particular person. And they were saying that the hospital is not involved in commercial activities, they were doing philanthropic activities and all, like no charges. So why should we consider this particular hospital as an industry? And what is the character of that particular activity? Whether they are running it for profit, right? Whether they have an employee and employer relationship. What is the purpose and object of that particular industry? So they said that hospitals are not here industry in 1960. Similarly, in many cases, if you read all these three cases, the High Court and Supreme Court also, they said that in the Safdarjung hospital case, in the management of Orissa hospital case, Dhanrajgiri hospital case, right? And in this first case, Justice Gajendra Gadkar, in 1960, Gajendra Gadkar and Justice Hidayatullah, thereafter in another judgment, maybe vice versa, you just check out, they read the definition of the industry. And they said that this definition need not to read together in toto. This definition has to be read in parts. That is the observation of Justice Gajendra Gadkar. And therefore, considering those arguments, they were saying that hospitals and all this will not be the part of industry. Whereas the same Supreme Court, right, in 1970s, when they have to discuss other cases, they overruled all the previous judgments. And then they said that hospitals are industry in some of the cases, where Justice Hidayatullah said that this definition need not to read in isolation in two parts, it should be read together. So they were interpreting the definition. And when you read together this definition, then anything can come under the definition of industry. Definition of industry is omnipresent everywhere. Anything can be industry. Anything you can include. But for that you have to read Bangalore water supply case. Then only you will understand. And finally, in 1978, right, when that matter went to the Supreme Court. But before that, there were other cases. These cases are all Supreme Court cases. This is all labor jurisprudence. Like D.M. Banerjee versus P.R. Mukherjee, Baroda Municipality versus Workmen, then Corporation of City of Nagpur versus its employees. Here issue was very simple, whether municipalities are industry. Whether they are doing, means they are doing different functions. Okay, municipality has to do many functions. If you read all these judgments together, all were dealing with somehow municipality. They are doing legal functions, sovereign functions, right? They have many taxes, they have the sanitation department, they have a NACA also, check NACA, they have many departments to collect revenue, water department, they may have the electricity also some cases, sanitation. So in all these three cases, Supreme Court has to elaborate. If you read Baroda, this municipality and this corporation of city, the issue was very simple. That when they are doing sovereign functions, right, regal functions, they may not come under the definition of industry. What can be the sovereign functions like main core? Yes. Okay. Apart from that, if you talk about municipality, what can be the sovereign functions of the municipality? Or legal functions of the municipalities?
Demolition of illegal constructions.
Demolition, yeah, that is their sovereign functions, correct? Municipality has to do with your city, construction of houses, taxes, right? That may be their legal or sovereign functions. So, because in Nagpur city case, the same issue has arose. So, Supreme Court here said, when you are dealing with the sovereign functions, you are not an industry. But in other situations, you are involved in certain activities, commercial activities also, then you are an industry, because employees are there, because employee and employer relationship is there. Even though you have this sovereign relations, right? Sovereign functions. These all three cases are very important. So here they say municipality can be the industry. Like hospitals can be the industry. That JJ hospital from that Bombay. Then we have very interesting case, these two cases. I always refer to these two cases. One is from High Court, Andhra Pradesh High Court, and then Supreme Court. That is University of Delhi versus Ramnath, and this Usmania University. There are many other cases, but I am just referring these two. In University of Ramnath, now you tell me whether the university can be industry. Okay? Ramnath was a bus driver. He was. They were running one bus for women's college in Delhi. And suddenly, due to some reasons, they have to stop the service of that particular bus, because the duty of that driver was that he has to collect girls from the city and to drop them to the university or that women's college which is coming under the university. Then when that service has stopped, automatically the job of driver has gone. So this Ramnath went to the tribunal, and then this matter was before the High Court, and then ultimately this matter went to the Supreme Court also. So they were saying that this university can't be industry. How you can say this university is an industry? And he approached to the court stating that he should get the retrenchment compensation, or he may get reinstatement also in the services, because he lost his job. So the first question the court has to decide whether this university industry, whether this Ramnath is a workman under the act. If he is fulfilling two tests to these issues, then we can give him the compensation. Otherwise, there is no need to give the compensation. So in this particular case, if you see whether these educational institutions are interested, they were not ready. They were not ready to consider. Okay. Now coming to Usmania University case. Here in Usmania University case, there was one printing press in the university. Now you tell me, I will give you the facts, you answer me. Okay. So there was one printing press, and duty or functions of the printing press was that they have to print question papers, your question papers, your course outlines, reading materials, okay, maybe your application forms and all. They were printing this off. One of the wings, separate printing press within the premises maybe of the university. Now some of the workers were terminated from the printing press, right? And these all workers went to the High Court stating that their services should be reinstated or the compensation can be given to them. Because if you are terminating in 3 months, the compensation provision is there under the Act, right? They should get it. And now the matter was before the High Court, Andhra Pradesh High Court. This is very old, 1960, very old judgment. So again the same question was before the High Court. Whether this university is industry, whether those workers are workmen under that. So here in 1960s, this is old, right? 1960s judgment, 63. They were not ready to accept this argument. They were saying that no, we can't give this. They are university. How university can be industry? How you can say hospitals are industry? We can't consider this. So in all these cases, except some 2-3 cases, in some cases Supreme Court said yes or High Court said yes. In some cases they were saying no. So they were confused. Which will be the industry? Then finally, when we have this Bangalore water supply case in 1978, okay, this is very landmark decision, very lengthy judgment. Okay. Here in Bangalore Water Supply and Sewerage Board versus A. Rajappa, they have introduced the test. I will tell you this story and then what happened after this judgment, of that also I will tell you. And now you read the new definition. Now Supreme Court the Supreme Court was fed up. They said, what's going on? Sometimes we are saying yes, sometimes we are saying no. What is this headache of industry? We should resolve this particular dispute of the industry. And here many workers, what was the issue in this case, do you know? In Bangalore water supply, what was the issue? I think you have not discussed this topic now. In your class, not done so far. You will do later on. Here the main issue was, since I am telling you the facts, there were many workers in the government of Karnataka, right? And there was some disciplinary action also taken against some of the group of employees. And there was recovery of those workers, some found guilty. So they have to recover the money, something amount from the workers. And this all group of workers, like some were working different, not only water supply department, from other departments also, many workers were there. They were approaching the court that why you are recovering this money from us, right? Even though there was disciplinary action, some terminations also done, some suspension also done. Okay. And they don't want to give the money back because once you have done the service, whatever, then no recovery. Even today, if you do something, no recovery is done. Right? If you have been paid, you are paid. Whether your act was legal, illegal, it doesn't matter in most of the cases. Okay. And then this matter was before the High Court. Then High Court also failed to deal with this issue. Then this matter went to the Supreme Court, larger bench. They said that now we have to settle this issue. So what can be done? What we will do? We will have one test. Okay, we'll give the test because definition Justice Gajendra Gadkar had said something, Justice Hidayatullah had said something, someone saying read together, someone is saying don't read together, interpretations, confusion was there. Then they gave the triple test, which is very important to identify or consider any institution as an industry or not. Okay, I will just take 5 minutes for this, and then I will just explain work committee and other mechanism. Okay. So here they give triple test. They said that, as explained in Banerjee also, this definition has very wide importance. So what is that triple test? Triple test said that if there is a systematic activity, there should be systematic, then only it can be industry. How you will explain systematic activity? It should be organized, right? Continuous work, because we have both organized as well as unorganized sector, formal or informal sector. So in those activities, there should be systematic activity, regular activity. Secondly, they said there should be a cooperation between the employer and employee. Okay? Whether he is signing on the muster roll, whether they have a register, cooperation, is there any cooperation? And third one, last and most important one, where the confusion has there. That point is that you are doing all these activities, right? Third one, for production and distribution of goods and services calculated to satisfy human wants and wishes. What you are doing, this activity is done for the satisfaction of human wants and you may say services, goods and services. Then in paragraph they said, not spiritual or religious, but inclusive of material things. What three tests they are giving? Systematic activity, organized relationship between employer and employee, and third one is production of goods and services for the satisfaction of human wants and wishes. Human wants and wishes to both sides. There are many wishes, wants. Can you satisfy all the wishes and wants? Whether they will come under the definition. Now here they are saying except that spiritual, otherwise Tirupati, Tirumala, Devasthanam will also be the industry. So in that case the judgment also, Supreme Court judgment, Supreme Court said ki except spiritual things, like you are doing puja, archana, whatever, right? Except that thing, rest everything can be industry. So here they are saying not spiritual or purely religious things. That may not come under the definition of industry. Rest anything can be industry. Wherever there is systematic activity, wherever there is a cooperation between employer and employee, wherever there is a production of goods and services for satisfaction of human wants, can be the industry. Now after this definition, what happened? After this judgment, this case was decided in 1978. Even today this case has importance. In 1982, the government of India had one amendment. They brought one amendment to the Industrial Dispute Act. And they tried to change the definition of industry. They gave the new definition, which is called as a new definition. But that amendment was never brought into effect. It was not in force. So what still holds valid in law? This judgment and the existing definition, that is section 2J of the Industrial Dispute Act. So what now the Parliament has done, if you see the code, Industrial Relation Code 2020, they borrowed that particular definition from 1982 amendment. They borrowed that definition from this Bangalore water supply case. So definition of You check the definition of industry of 1947. You check the definition of 1982. You read the Bangalore Water Supply Judgment, and then you read the Industry Relation Code, where they have the new definition. So what they are trying to do here, that anything can be industry if they are fulfilling this criteria. If you don't fulfill, then it is not an industry. Okay? So you will read this particular judgment. Now what are the mechanisms are there? We'll just take 5-10 minutes, okay, more, then we'll close. 5 minutes more. Okay. Now, what kind of mechanisms we have under the Industrial Dispute Act? Just 5 minutes, okay. We have work committee under the Industrial Dispute Act. We have many mechanisms. See, the purpose of the Industrial Dispute Act is not to adjudicate everything. They don't want court burden also. The purpose is that issues should be resolved either through court or through any other mechanism. Therefore, they have introduced work committee under section 3 of the Industrial Dispute Act. And what is the duty of work committee? Work committee has to just maintain the relationship, nothing more than that. There is one judgment also, that is Northbrook Jute Company's case, Supreme Court judgment is there. Northbrook Jute Company case. In that particular judgment, the employer wants to introduce one scheme, that is called one rationalization scheme. This is one scheme from that North India. This is from I think West Bengal or Uttar Pradesh. So the scheme purpose was to terminate the services of the employer, because they want to have the less worker and more production. They thought that the workers are more in number, production is less, so what we'll do, we'll give them more work, we'll remove the services of the workers, and within limited number we'll do more production. That was their basically idea. Some G-job or some scheme they want to introduce in that case. And they agreed with this work committee, because they had a work committee, and work committee is basically a combination of workers representative and employer representative. Both should be equal number. If 3 are here from the employer side, 3 should be from the employer side. 3 employees represent 3 workers. 3, 3, 6 or equal number, whatever number you can have. So what the work committee has done, they agreed with the scheme, and the trade union was not aware. The leaders have decided themselves, we will introduce this scheme. Then when this matter come to this cognizance of these workers, they shouted. They said, how you have done this? What is your role? What is the function of the work committee? You should not exceed the power or functions. Then this matter went to the court. Then they said that whether this work committee role is to agree on any aspect without taking cognizance on consent of the workers. Then Supreme Court said the work committee has very limited role. Your only role is to maintain the relationship, peace and industrial harmony. Don't exceed your functions. This is first authority mechanism. Every matter or any matter can be resolved through this work committee initially. That is what the purpose. Then they have the conciliation mechanism. Then they have the board of conciliation. There will be conciliation officer. Every industry will have the conciliation, or the government will appoint the conciliation officer. If any matter which has a more importance or which is affecting more states and all, then you can have board of conciliation. Section 3, 4, 5 of the Industrial Dispute Act. Then they have a court of inquiry. This is also one body of the these workers and all, they will look after the issues. Then they have the, after court of inquiry, they have the labor courts. Section 7. Then section 7A and 7B, that is industrial tribunal and the national tribunal. And then you directly read section 10, that is the reference to labor code. And then you have section 10A, that is voluntary reference to arbitration. So initially you can resolve the dispute through these mechanisms. If it does not resolve, then you can refer the matter to the labor court. 45 days and some 45 days time and all is given. Okay? So what they have to do, don't directly jump to the labor. No matter directly go to the labor court. This is one of the object of labor laws. Initially all this matter has to be decided by the authorities, either the labor commissioner, assistant labor, deputy labor commissioner. And these all matters has to be forwarded to these labor courts. Okay? So these mechanisms are there. Rest we will discuss in next class. Okay? Otherwise you will say that this teacher is very bad. Okay? So I will stop here. Thank you so much. Rest will continue tomorrow. Other topic.
Yes. Okay. Good afternoon.
Good afternoon, everyone present here. I am here to present the vote of thanks. I would first like everyone to give a round of applause to Dr. Khobragade. Dr. Khobragade has very patiently explained a lot of concepts of labor law to us. He has, from the beginning, from the history of labor law to the Trade Unions Act, the history of Trade Unions Act, the Distributions Act, the many aspects of the definition of industry, and he has very wonderfully compared the labor codes and the labor acts, multiple labor acts that have been there. And sir, labor law for us is not a very boring subject, because one of the aspects of our novice moot court was also labor law. So I thank everyone for being patiently listening to this wonderful lecture, and I would also ask Dr. Khobragade to come to our honorable university and deliver much many lectures on intellectual property rights, human rights, and also labor law. Thank you very much.